first, yes, it does make a difference. Because women can bring a different perspective. When, particularly as you listen to evidence, I can recall, for example, having arguments with my judicial colleagues in the trial chamber who would say, no, that woman can't be, that's not realistic what she's saying. Mm. And I could perfectly understand what that woman was saying. Mm. Similarly, in Papua New Guinea, I sat as a judge alone, as a trial judge. But in the Supreme Court, I sat with 2 other judges as an appeal court. So inevitably, those other 2 were men, because I was the only female among the 17 judges. Mm. And again, they would say, well, this is not sensible. Why did she talk to the man before he raped her? Mm. And I would say, but she's trying to extricate herself from a dangerous situation. She's trying to avoid him. It's perfectly logical what she was doing. Mm. Because I would have done that. That's the way I would have done it. If I was in it, I would try and talk my way out of it. Mm. Whereas a man presented with evidence that said, oh, she spoke to him, we're interpreting it as a consensual situation. Mm-hmm. Yes, I was able to talk them around on that. and I think that is a female perspective on evaluation of evidence, on credibility. There would be also issues, maybe listening to even other cases, robbery. Why did she go there? Or why did he go there? Well, why shouldn't he go there? You cannot, because you go out to, let's say, a shop, or in Papua New Guinea, a very popular place for robberies was petrol stations, because someone was stationary. Well, why shouldn't they go to the petrol station? The way of looking at it is they were looking at it after the robbery, not what, and I would have to try and persuade them that you must look at things as they happened. Mm-hmm. And I think that's a different form of logic that I didn't come across with my male colleagues. In the international courts, there were still arguments, believe it or not, among the judges as to whether rape, even though they were in these horrific conditions where these complete strangers would come into the village armed, pull them out of their houses, do things to them that in public that no one would do in public. And they would still say, yes, but we haven't heard whether she agreed or not. So it took that also were the kind of argument that we would, or discussions we would have. And as a female, I think I did bring a slightly different perspective on how to assess evidence. On human rights, I know that in Papua New Guinea in particular, I as an individual judge was much more aware of international human rights treaties. Papua New Guinea, like Sierra Leone, is a common law country. And in the common law, a treaty is not applicable as part of the law till it's both ratified and implemented into local legislation. It is different from the civil law system. And there was a continual argument among the lawyers, particularly Sierra Leone was particularly noted for this, where I would say, well, the International Convention on the Rights of the Child say this, that, or something. And they would all say, yes, we've signed it, but we haven't brought it into domestic legislation. And I ruled more than once that even though you've signed it, you have maybe not legislated it, but the fact that your government has signed it means you cannot ignore it. And you can look at it, a treaty, CEDAW, or in saying, how do I apply my domestic law? How do I interpret it? Well, I can look to an international treaty that government has signed, because they didn't sign it for nothing.